5 seconds to go. Start. According to the defendant, the suit lands were self-acquired properties of Diwala Ghosha and he had right to make will and to bequeath the said properties. According to him, the plaintiff had separated from Diwala Ghosha before many years and he was residing at village Ghantoli at his father-in-law's house since last 30 years. It is also contended that since that time, that is, separation of the plaintiff from the deceased Diwala Ghosha, the deceased has purchased the lands which are self-acquired properties of the deceased. It is also contended that the deceased Diwala Ghosha has acquired the suit lands under the provisions of the Bombay Tenancy and Agricultural Lands Act and therefore the concerned court has no jurisdiction to entertain the suit. On the basis of the pleadings of the parties, the trial court has framed following issues at Exhibit 10. Does the plaintiff proves that the deceased Diwala Ghosha had no authority to execute a will in respect of suit property? Does the plaintiff proves that the suit property is of the HUF of the parties? Does the plaintiff proves that he has got half share in the suit property? Does the plaintiff proves that he is entitled to partition, separate possession and means profit? Has this court has jurisdiction to hear and decide the suit? Is this suit property valued for court fees and jurisdiction? To what relief, if any, is the plaintiff entitled? What order and decree? Whether the plaintiff is a joint tenant with the deceased Diwala in respect of the suit land. After considering the evidence on record, the trial court held that the suit properties were the self-acquired properties of the deceased Diwala Ghosha. The trial court has also held that the plaintiff has failed to prove that the suit properties were undivided family properties of the parties. The trial court further held that Diwala Ghosha had executed will in respect of the suit properties and the deceased Diwala Ghosha had executed the will at Exhibit 49 in a sound disposing state of mind and had bequeathed the suit properties in favor of the defendant. It has also held that the plaintiff has no right and interest in the suit lands and ultimately dismissed the suit of the plaintiff. Being aggrieved with the judgment and decree of the trial court, the plaintiff has preferred first appeal, being regular civil appeal number 33 of 1981 before the appellate court Surat, which has been decided by the assistant judge Surat, while judgment and decree dated 17th November 1981, whereby the appellate court has framed the following points. Whether the defendant proves that the testator Diwala Ghosha was in a sound disposing state of mind on 11th January 1975. Whether the will Exhibit 49 dated 11th January 1975 is proved to have been executed by Diwala Ghosha in a sound disposing state of mind. Whether the plaintiff proves that the suit properties are undivided joint family properties of the parties. What order? The first appellate court has decided the aforesaid points in negative and has ultimately passed the order to the effect that the plaintiff is entitled to partition with metes and bounds and also directed the collector Surat or any subordinate to the collector deputed by him to make partition and separation of the lands and has also passed order for drawing the decree. This judgment and decree of the first appellate court has been challenged by the defendant in the second appeal. Ms. Dhara Shah, learned advocate for the appellant, has vehemently submitted that deceased Diwala Ghosha has executed the will whereby the properties have been bequeathed to the appellant herein. Stop.